Good evening. This is John Milburn for Laws 12065. This is Foundations of Property Law. We have a full house just about. Thank you very much for joining us for the live session. And if you're watching this as a recorded session, please ensure that you do take an opportunity to join us for the live session whenever you can. I need to thank Supo for being very cooperative in changing the timetable for Laws 13010, Evidence Law. As many of you know, there was a clash between this unit and evidence, and evidence is now, I believe, 8 p.m. So following on immediately from this session. But even though there was some discussion of changing this unit, as you can see, we're sticking with the Wednesday night, 7 o'clock. And when I give any reference to times, that will always be Queensland-based time. So please undertake your own adjustments in that regard. Now, I am recording the session and I will record the session every week, but for next week, I'm going to try something a little different, and I'll let you know what that change is when we get to the end of the session. If I forget, please remind me. But it's just a little bit different approach to the way we're doing things this time. So for those of you that have worked with me in the past, nice to see you again. If I haven't worked with you previously, I look forward to working with you this term. My approach to the study of law is that we should all attempt to do this collaboratively. So don't think of me as being someone that is sitting here always telling you what to do or how to think. It doesn't work that way. Now, unfortunately, it may be that I do most of the talking, but I'm happy to reverse that at any stage. But don't necessarily assume that what I say is absolutely correct in all circumstances, and you should not deviate from it. Quite the opposite. I encourage people to think independently, to challenge that which was said, to make contributions, to add to the discussion, to ask questions. It's all part of the learning process. And that's for you and for me. So I have had a very fulfilling career in law. I started studies in 1977 at University of Queensland, straight from school, as was something of a norm back in those days, and almost immediately straight into property law. As you will hear, some of the things that we'll be talking about during this unit are things that I last heard or dealt with in about 1977 or 1978. You might think that's strange, but I'll explain what I mean by that and why I'm making that comment as we progress. I say that I've had a fortunate career in law because I've had a great deal of variety. And one of the things that stands out for me in the practice of law is that literally every day there's something new, something to learn. And it's impossible to know everything about law. So you'll see that part of my focus is to encourage you to learn independently. From the CQ University perspective, we call it the flipped classroom model. You may have heard that term previously. What it means is that I'm a lecturer, but I'm also very much a facilitator of your own independent learning. It wasn't like that when I went to university. It was very much listen to what the lecturer says, take the notes and go from there. So you'll excuse me if some of my style reflects that because that's what I'm used to, but it shouldn't always be that way. And as I said, I look to encourage you to independently make comment and undertake a process that is not necessarily directly aligned with what I'm doing. So the focus of the unit is, as much as I can make it, practically orientated. Now, I'm not suggesting that I'm facilitating, I almost said lecturing, teaching, foundations of property law exclusively for those that want to practice in law, because I understand that many won't, and that's okay. But I do want to, thank you, Lachlan, I do want to make sure that we are looking at this from a practical perspective so that it's got a real element to it. Now, it's a bit of a challenge in foundations of property law because a lot of the material relates to that which was determined by English courts in the 12th century onwards. And I have a problem with that. Um, I'll mention now two things about my personality, which there's a reason for this. The first is that I'm the type of student that historically would always sit, the annoying ones, right, right in front of the teacher with with the arm up, like. And if any of you have seen the movie Election, I'm like the Reese Witherspoon character. It's a good movie. So kind of annoying in that sense. And the second is that once I'd finished my work for the day, I didn't really want to talk about it. If people would ask me questions. Now, the reason that I make those comments is in relation to the first comment, what I have noticed about some areas of practice and study of law is that we have, I think, a bad habit as lecturers and facilitators sometimes. What we do is we make our opening comments based on the development of the law in certain ways. We talk in the context of property law. I might start talking to you about the Magna Carta and cases that were decided in the 12th and 13th and 14th century and talk to you about this whole development of law. And then after 30 minutes, I'll say, but that doesn't apply in Queensland now because it's all been repealed and replaced with legislation. Now, for my personality type in learning, that's really quite annoying because, coming back to the first point, sitting in the front row, taking it all in immediately, you're like this sponge. You're saying, I've got to take this in immediately and ingrain it as I go. So if I'm sitting there for half an hour, I'm working really hard, and then after half an hour, I'm told, forget that, it doesn't apply anymore, and it's deflating. Do you know what I mean? So you're thinking, well, I would have been better off just not listening for the first half an hour, and I do want you to listen. So as much as I can, I will try to change the emphasis from that which is in the study guides and the textbook in particular, so that we're not so much learning about the things that happened historically and then making adjustments. But I'll flip it round if I can and talk about what happens now. And then I might relate to, after that, I might relate to where it was and how it got there. If you worked with me in statutory interpretation, you probably noticed that I did the same thing there. In that, I started by saying, in the context of interpreting statutes now, we adopt the purposive approach, Project Blue Skies, the Acts Interpretation Act, and here are the rules as they apply now. Then eventually, 6 or 7 weeks down the track, I said, now these are the rules. These rules were modified by common law and equitable principles, and then I'd talk about the literal rule and the mischief rule, etc. Now, that's just my style. It's not to say it's necessarily right. Statistically, it's probably wrong because most people talk about the historical developments first and then lead into what it is now. So what I'm saying is not to suggest that the approach adopted, for example, in the textbook is wrong. It's just that I adopt a different approach. So if you're wondering why what I say doesn't match the order of the text, hopefully that gives you some insight, some reason for it. And it all goes back to me sitting at the front of the class with my hand raised early on saying, what about this, and trying to remember it. So the focus will be as much as I can on practical aspects. And the problem with foundations of property law to some degree is that we are talking about foundation principles, which don't necessarily easily translate to practical application. Now, flowing on from this unit, we have land law, and it becomes much more practically orientated in terms of the content in land law. And then for those of you that go on and do conveyancing law, it's full on practical application. And it may come as no surprise that of the three, my favourite unit is conveyancing. Some of you might say, well, that's boring. There's nothing much interesting in conveyancing. And I can assure you that it's absolutely the reverse. And I have a great deal of respect for conveyancers. I don't know if we have any conveyancers in our unit, but if we do, please raise your hand. I want to give you some congratulations. And if you're watching this as a recorded session, let us know. Taylor works in conveyancing. Good on you, Taylor. Thank you for letting us know. And I have a great deal of respect for the work that you do. I think conveyancers are amazing, the speed and accuracy with which they work. And Taylor might agree with me that conveyancing is full of different things that crop up and lots of practical scenarios. But in order to answer those practical conveyancing or property-based discussions or problems that arise, we really do need to know something about the foundations. So in this unit, we'll be talking about the rules and the principles that go towards the creation, the transfer, and the enforceability of interests in property. Now, when you saw this was a course, a unit on property law, I suspect most of you thought, well, we're talking about real estate, aren't we? But in fact, it's very much a split between real property and personal property. Now, just to get you working a little, can anyone tell me what we mean by real property? What's another way of describing real property? Use the chat facility or unmute. Karen?
Land.
Yes, land, absolutely.
Sure.
Real estate. Yep, real estate. So what do we mean by personal property? Anything that can be removed. Yes. Does it have to be tangible? Can it be intangible?
It can be money.
It can be money.
Or
now,
ideas, perhaps.
What was that, sorry, Carolyn?
Ideas.
Ideas, yes. So it can be intangible as well. And Shona says, well, let's go with perhaps the obvious, given the answer to real property, we'll say anything other than land. And there's a bit to be said for that. There are some funny concepts that might appear to be funny concepts in foundations of property law. And there are some really horrendous terms. Now, again, if you've worked with me in the past, you know that I'm a huge fan of plain English communication, and the writing that I'd like to see from you. This is a heads up. If you haven't worked with me in the past, this is a tip for your assessment and your exams. I want you to write in a way that makes sense to a reader easily. So I'm not particularly impressed by the use of lengthy words. I'll try and keep it simple. Lengthy words where you can use something in a simple term. And of course, we have a lot of words that you would never use in practice. When you're reading the text, incorporeal versus corporeal, hereditaments. I mentioned earlier that another thing that personality trait is I don't really like talking about work when I get home because I've put so much into it and you're tired by that stage. And same thing applied when I was, 17, 18-year-old student. And I recall thinking that property law was particularly difficult because there were so many terms that I'd never heard of previously. And when I worked out what the meaning of those terms was, it occurred to me that shouldn't we just say something instead that's much more direct and much more simple? Why are we trying to say things like hereditaments when we could just say something that can be left in an estate or by a will? So when I got home after being very tired of putting my hand up, trying to take it all in and being exhausted learning all these terms, someone said to me, and this is, I was just 18 or so, at the end of the university studies in week 1 of property law, how was property law? It was pretty tiring. What did you learn about? Incorporeal hereditaments. And that was the last time that anybody bothered asking me a question because the response was, oh, that's nice. Do you want a cup of tea? So you will find there's a lot of terms that really we should be avoiding. Now, I will make a disclosure here. My least favourite act of any piece of legislation that I can think of, Commonwealth or state, is the Property Law Act. And I'll tell you why. Because if we're dealing with a subject that's called Foundations of Property Law in Queensland, and you're aware that in 1974, the Queensland government passed an act called the Property Law Act, you would think that this unit will be all about considering what's in the Property Law Act and applying it and providing all the answers. Well, we certainly refer to it, but there's not much in the Property Law Act that really helps us. And we have a disparate collection of acts, both Commonwealth and state, that together contribute to our property law. But even then, we have a whole range of case law, common law, that we have to tie in with it. And I would love to see property law consolidated, codified almost in Queensland, and it's eminently doable. We would ditch all of these archaic terms, we'd replace them with plain English language, and we'd set it out in a logical manner in 1 or maybe 2 pieces of legislation that deals with everything. So that's my little disclosure that when I mention the Property Law Act, you'll probably note a little snarl on my face because it's my least favourite piece of legislation. Now, those of you that really like the Property Law Act and you want to go into bat for that piece of legislation, feel free, because I'm not necessarily right. It's just my opinion. And I'm not speaking for the university, and I'm not speaking for you or anybody else when I say I don't like that piece of legislation. We could have done much better. Just my opinion. So, having said to you that in this unit, we don't have a piece of legislation that really helps us anywhere near as much as should be the case. The question, and given that I'm not really keen on talking about cases from the 12th and 13th century, where does that leave us in terms of learning foundations of property law? Well, a bit all over the place, really. And we will try and tie it together. But if you feel a bit overwhelmed at the start and you feel that there are just too many pieces of information that are being drawn from different sources, don't worry too much. We'll see if we can tie it in together. And hopefully, by the end of the unit, it will make some sense. Now, one thing I do like about this unit is if you look at the list of topics, we actually have only 7 substantive topics. We have 12 weeks, plus the SWOT vac and the exam week, as well as vacation week. So I do like the way in which Dr. Nancurro, for whom I'm babysitting this unit, and thank you very much to Dr. Nancurro for allowing me to do so. What I do like is that Dr. Nancurro has set out a framework that is logical in terms of the process, and there's plenty of room for revision and, for want of a better term, tying it all together. So we'll be dealing with concept of property, classification and boundaries between types of property, possession and title, title to personal property, and we do that in the first 5 weeks, so there's 4 topics. Now, in the first 4 topics, we have a lot of material that troubles me. So I won't be sticking to the script for this. I'll be tying things in, and I'll be encouraging you to come up with a plan that works for you in terms of answering legal problems that are based on foundations of property law, which then leads me to the first assessment. Now, the first assessment you would have seen on Moodle. Has everyone actually seen it? All right, and I'll explain the rationale for this and why I've departed from the script, for want of a better term, in terms of the first assessment. I was going to attempt to share, but the problem is that I'm not sure about the bandwidth may be a problem. So if you have access to Moodle and you haven't yet had a look at the first assessment, please do so. And correct me if I'm wrong, but everyone can see that, can't they? You can find the link to the first assessment and you can download the assessment. I think it runs for 5 pages. Has anyone been through that process and found it? Yep. So Lachlan has found it. It's there on the front page and it's on the tab. Yeah, the side tab is gone, but it's at the top now. So Moodle has been redesigned, but correct me if I'm wrong, but you should see in the top ribbon now, on the left, information and then assessment. So you can access the first assessment during that. Now, Nicole says, and this is an aside, we still don't have any lectures for this class yet. I know, Nicole. And here's the thing. Because I'm going to teach this in a different way, I haven't recorded any lectures per se. So this will be a single Zoom session per week deal. There are some recorded sessions that I'll provide to you in advance, but generally the session that we have on the Wednesday night will be it. So it's a lecture/tutorial type session. So you won't necessarily see any lectures in advance. All right, so has everyone found the first assessment? Lachlan says the assessment tab is gone. Is that right? Has anyone been able to find it? Yes, Sharon?
It's across the top of your Moodle. It has information assessment.
Yes, so it's in that top ribbon.
Yes.
Got it? All right, so we've just found it. And also under the welcome information, you'll see a link to news forum and then this weekly lecture. And then you'll see the assessment tabs there as well. E-reading lists only says evidence and proof under that tab. Yeah, I don't know why that's there, but there's nothing to do with evidence and proof in this unit. But hopefully you've seen the assessment. So the assessment now is for assessment number 1, and it's called, in inverted commas, group discussion. Has everyone seen that? Okay, good.
Yeah.
All right. Now I've just made this as clear as I can. Assessment 1 is not a group discussion. It's a misnomer. It's a misnomer because I'm coming in and taking over this unit just for this term, and I don't want to upset the way in which Dr. Nankaro has structured the unit, but I need to work within what I'm comfortable with, and I'm not comfortable with a group discussion. So I hope that makes sense. Now, if you have any problems in finding this material, let me know. So the first thing is that this is an individual assessment. It's not a group discussion. And what I'm looking to do is have you consider the first 4 topics, which covers the first 5 weeks. Now, the assessment is due during the 5th week. So I think it's the Thursday of the 5th week, which is Easter Thursday. 750 words. excluding any contributions to class discussion. So even though I've said this is not a group discussion, it's individual, part of the assessment, so that there's some degree of consistency here, is if you provide a contribution to class discussions, then you can add that in as an annexure and it doesn't count towards your word count. So what I'm looking for in this assessment is for you to come up with a way of solving legal problems in relation to basic property law and concepts and issues. What that means is that I'm asking you to now, from this week, start preparing essentially for the examination, which I would ask you to do anyway. So the exam preparation starts now. I've already given you one little hint for the exam preparation, but the first assessment, read it as if it's for you to assist you in answering the exam question, a real problem based on property law disputes. Now, the usual rules apply. Upload your work on time. If you don't upload your work on time, there's a 5% penalty. There is a cut-off date. And the reason it's so quick in the semester is, well, firstly, it's only worth 10%. The second is, I want to get you working straight away from week 1. Number 3, I want you to start thinking independently, which is why we've got something special and unusual next week. I want you to start thinking about how you would apply these concepts in answering a problem. I hope that makes sense. So when you read the textbook, there's a whole bunch of theory. There's a whole lot of words that you've never heard previously. Given that I'm looking at this from a practical perspective, I can guarantee that lawyers are never confronted by a situation where a client comes in and says, I'm here for a half-hour consultation and I'd like to pay you $200 so you can explain to me what is meant by incorporeal hereditaments. That's just not going to happen. What is going to happen is that people are going to present you with problems, and these are based on property law, and you need to understand how to apply these principles, these issues, these theories in a practical sense. So your first assessment piece is almost like a toolkit. For those of you that work with me in Introduction to Law, you'll know that I was pretty keen on the toolkit process, and I think that's no longer being used in Intro, but hopefully you get the idea. Now, there are some components of self-assessment here for the first assessment. If you look at the rubric on second page or third page, you'll see that one of the criteria is reading the prescribed and supplementary material. Don't worry too much about reading the supplementary material. If you do, that's fine, but if you don't read the supplementary material, you're not going to lose marks over it. But what I want you to do in the self-assessment is to say, I've read it. That's all I need you to do. I'll take your word for it. Attending the live or sessions each week or viewing them later, I just want you to say you've done that. Now, week 2 will be an exception to that. So if you can't make week 3 for the live session, but you watch it at a later time, that's fine. You won't be penalised, but as part of the self-assessment, I want you to say, I looked at it, and you can even put in the date and time, for example. And then attendance or reading other than prescribed, if you find something that was particularly useful, then you can add that in as something which is part of the self-assessment to say, I came across this, I really like it. But don't just do it for the purpose of the assessment. Do it because it actually helps you in understanding the content, and it helps you in being able to answer a real problem. So I hope that makes some sense of what I'm looking for. So I want you to show that through self-assessment, I've read the material, I've read supplementary material to some extent if you have. It doesn't have to be what I say, supplementary material, it might be other material. You've attended the live session or you've viewed them later. You've read the prescribed material or other readings. Going beyond that, provide some links. You've maybe contributed to unit discussions, which might be you've answered some of the weekly problems or you've raised an issue in Q&A, things of that nature. Not just for the sake of it, not just for the sake of getting a better mark out of 10, but because it's genuinely helping you or others. Then really the substance of the assessment, parts 5 and 6, describe some of the key issues in topics 1 to 4, and number 6, which is really the heart of the assessment, the most important part, identify the process by which you would answer legal problems relating to topics 1 to 4. Now, you may say, I can't work out what the legal problems are, and that's okay. But the point of the exercise, and it's only worth 10%, and it's probably pretty easy to get a good mark. The point of the exercise is I want you to personalize the experience as much as you can so that what you're reading, what you're hearing, what you're considering makes some sense to you in a more global sense, and try to think about how you'd use this information if you're answering a real life problem. Now, does that make any sense? Do we have any questions about that first assessment? Some of you will be horrified by that. Some of you will say, I need more structure. I need you to tell me exactly what it is that you want. Can't you just write a question that says, please explain incorporeal hereditaments, 5 marks? I'm not going to do that, sorry, because that's not going to help you, I don't think, in terms of answering legal problems. Okay, if you have any issues with that, then please ask through Q&A and we can go from there. And you'll have a good chance to chat about that next week as well. All right, all good? So some of you now will either be overwhelmed and thinking, I don't understand. I want a situation where we start on page 1 of the textbook and we work through each page and each chapter, which coincides with the textbook and the study guide until we finish. And John, you're telling me that you're going to be jumping all over the place. I'm overwhelmed by that. I don't get it. So remember, of course, those of you that did intro with me will remember the quote, thinking like a lawyer means keeping a cool and clear head and speaking and behaving rationally when others around you may be panicking or overreacting. Thank you, Keith. So just be careful about not being overwhelmed to a degree where it stifles you. Okay. And think about the objective. So the idea of the first assessment is to give you a better chance of answering a question in the exam. I don't want you to be starting your exam preparation in week 10 once you've completed the second assessment. I want you to be thinking about the exam preparation now, which is why I've just reconfigured assessment 1 so that it helps you in that regard. And if I do give some exam hints, which I will do probably most weeks, then please make sure that you have a note of that. Keep some separate document or separate folder or something. All right, let's just take a moment to think about Moodle. We had a look at Moodle. I wanted everyone to have a look at Moodle straight away. Has anyone got any questions or comments about Moodle? Can you find where to ask questions, Q&A? Can you find the assessments? Can you find the, we've already had the question, where are the lectures? Well, now we know the answer. All good? All right, but Q&A is probably the most important thing. It's under Information tab at the top left. So hover over the tab Information and you'll see Q&A should be below that under Unit Profile, etc. Now the second assessment is the online quiz, and that is due on the 21st of May. So there's a long way to go with that, but I'll release it probably in the next week or so, and it'll be 3 questions of a pretty basic nature. And again, the idea of the questions is to assist you to write something that will help you to answer the question at the end of the term. Now, with the examination, which is the 3rd assessment, 60%, I haven't finalised the format just yet, but it's likely to be a problem worth 30% and 2 essay questions, both worth 15%. So that makes up the 60% for the exam. The exam will be 2 hours in duration. I hope that's consistent with what's in the unit profile. It's always a little tricky when you're taking over someone else's unit because I may miss something. So if what I say is not reflected in the material information guide at any stage, please let me know. I'd appreciate that. But for the exam, 2 hours, a problem question worth 30 marks. So you'd want to answer that within an hour. And then you've got half an hour for each of the essay questions. One thing that you can do now, in addition to undertaking the work for the 1st and the 2nd assessment in your private study, is to start to write some answers to the exam questions. Now, if you've worked with me in the past, you've got an idea what I mean by that, and you've probably looked at my video level 3 examination and short window assessments, take-home papers. So when I say preparing for the exam, if you come across a concept and you've worked out what that means to you, and you think that you may need to refer to that or include it in your exam, then write out something, a paragraph or 2 paragraphs, that best describes that concept in just the right way to get the message across so you can drop it into your exam answer. Now, with the exam, it's handwritten. Sorry for those of you that do everything by typing. So it's back to the old-fashioned handwriting for the exam. But you can take in your textbook, can't you? You can take in legislation. You can take in pretty much anything other than access to the internet. But you can take in your own pre-prepared written material that you can effectively transcribe into the exam. Now, you don't have to answer this, but does anyone do that? Does anyone sort of adopted that practice?
Absolutely. It helps when you have no time and lots of questions. Absolutely.
Oh, thank you, Amy Lee. And I think, Natalie, you're...
Exams
Yes,
that I took some practice exams that I did in corporations law last semester into the exam with me, that I'd had him, the lecturer, check over, and he's, yeah, it really helped a lot.
Good. Excellent. Now, you may not have too many practice and past exams for this unit with me because I'm adopting a different approach. Do you understand? So it's not likely that you'll get a question that is, you know, based around the case law from the 19th century, if I can use that term. So it may be that there's a different approach and therefore there may be a less relevance on past papers than might be otherwise the case. So that's just really saying that I've got a different style to other lecturers, and certainly a different style to what's in the textbook. All right. And of course, it'll become more apparent where I believe the important areas of practice are in this unit. So just to give you some idea, the Personal Property Security Act is really important and it's relevant. Native title, it's important and it's relevant. Issues to do with an introduction to the torrent system, well, that's important, that's relevant. it may be that there are issues that arise on a case that's highlighted in the material. So that might be something that's relevant. Fixtures is important. It's relevant. It comes up all the time. And it may be that any question that I ask you in the examination will try to tease out areas from different parts of what we study. So it may be that when you look at the question, you can answer it by reference to one topic only, or it may be that there's enough in the material for you to draw upon different aspects of different topics that we study during the year. So that's a non-exclusive list of those things that I find important from a practical perspective now. So what I'm asking you to do tonight, it's really a G-up session to say, start thinking about the exam, think about what it is that you want to achieve at the end of the day. Those of you who've worked with me in the past, you know what I mean by keys in the fridge, don't you? Yes? Keith knows what I mean by that. Yep. Others? All right. And if you don't know what I mean by keys in the fridge, see if you can work it out or ask somebody. All right. So it's all to do with preparation to ensure that you don't let yourself or somebody else down when there's something that you need to do, that you need to finish. I'm very keen on collaboration. Now, that's not collusion. So I would ask you to please do some research on what I mean by appropriate collaboration. So I encourage you to collaborate. It's important. It's part of the unit, and many of you may have worked together in the past and formed some study groups. If you haven't, please do that. Now, when it comes to that which is written after you've collaborated, make sure that it's your own work. And if it's not your own work, that's fine, but just ensure that you identify it as the work of someone else and appropriately reference it. If you reference the material, you're on very safe ground, aren't you? Now, in order to reference the material, though, you need to have a good grounding in the Australian Guide to Legal Citation, fourth edition, please, and make sure that you reference your material well. I know from working with some of you in the past that you do know how to reference well. If you are good at referencing, I'm going to ask you to consider something for the second assessment. Sorry, for the second week, for next week at Wednesday at 7 o'clock. If you're good at preparing for the exam, might ask you to do something special as well. If you're good at coping with a great deal of material, cataloguing it, then you may have a special task that I'd ask you to volunteer for. And if you're the sort of person that can coordinate groups, then you might have a special task as well. Now, if you do have issues, if you have problems, please ask for help. That can be of your fellow students, it can be of me, or it could be of the student success team. So I think the email reference for SAT is sat@cqu.edu.au, and have a look at what the student success team can assist you in. Now, what I'm looking for in this collaborative self-learning approach is, amongst other things, an ability to cope. And there's a quote from The New Lawyer, the text that you may have used in Introduction to Law, and it's at page 369 of the second edition. And it says this: learning self-management skills at law school is important if you are to ensure that you maintain good psychological health during and after your legal studies. For example, a study led by Catherine Lay assessed 955 students at University of Adelaide found that 58% of law students were psychologically distressed. 58%. That was the highest level of distress across all of the disciplines. Medical students were second at 44%. So what it shows is that there are special issues for law students. it emphasises the need for students to take particular care of their psychological health. So forming some good associations with your colleagues, I think, is a good way of doing that. Now, you might say, I don't want to do that. I really like to learn independently, and that's fine. There's no problem with that, and I'm a little bit like that, to be honest. But you need to think about what works for you and do something about it. I know I haven't been talking much about property law tonight, but that will come. Now, if you don't have good research skills, please take some time in this first week to learn how to research. Just do a quick poll to keep you busy. If you wanted to learn something about property law, for example, from a textbook or a platform that wasn't the textbook that's prescribed, are there any platforms, legal sources you'd go to just to get a general information?
The encyclopedias like Holsbury's Australian Laws is very helpful, as is Laws of Australia on the Westlaw platform, that give very concise entries for a whole range of topics.
Absolutely. I think that's a great place to start. Thank you, Ivan. So Halsbury's, LexisNexis, or the Laws of Australia, which is Westlaw, both excellent platforms. Nicole says university study guides can be a great resource, but you need to be careful. Websites can be very good as well. Queensland Law Handbook, says Megan. Yes, that's very useful also. So there's no right or wrong answer here, but just try to find a go-to resource so that if you are struggling, you've got somewhere else to look. Now, the textbook is very good. It's very comprehensive. It has a lot of excellent material, but it may not be put together in a way that works well for you, and that's really a personal thing. So find somewhere else that might assist you is generally what I'm referring to. Tammy says, still refers to the toolkit from Introduction to Law. That's great. And Nicole, linked to website, provides summaries. So make sure that you have some good way of accessing quality legal materials. Just one thing I want to emphasise is the difference between the primary and secondary sources of law. So, for example, if we're dealing with the Personal Property Securities Act, you can read about that from secondary sources, or you can go straight to the primary source, which is the legislation. I want you to go to the primary source wherever you can. Part of the reason for that is that if you're in a courtroom situation and a question arises, and the question is, or a statement is made, and the court might say to you, well, what's your authority for that proposition? So you make some statement and you say, here is the legal position. What's your authority for that proposition? The court is not looking for an answer that is something like, in the textbook written by such and such and such and such, at page 7, it says that. Court's not going to be interested in that. What's the court interested in? It's interested in a section of an act, and if you can't provide a section of an act, it's looking for the name of a case. And that is 99.9% of the time what the court expects. So it's only in those rarest of situations where we don't expect the answer to be in legislation or in a case that a reference to a textbook or a secondary source is acceptable. So you can understand that's part of my thinking. So another exam tip is, if you're going to cite something as authority for a proposition, wherever possible, provide the legislation or the case. Don't refer me to a textbook that talks about the legislation or the case. Does that make sense? It may be that there's some commentary in that textbook which is particularly relevant, and that's fine. But if you're referring to the case, refer to the case, refer to the legislation. So where there are instances of legislation or case law in this unit, please do look at the primary sources first, and in many ways the answer will be there. So have a look at the PPSA at a Commonwealth level and you'll get a good idea of what I mean. And then if you find it confusing or difficult, then you can maybe look at the secondary sources for a better explanation. Always remember, of course, the possible application of statutory interpretation principles if you're looking at an Act. So the Acts Interpretation Act, Queensland or Commonwealth respectively, but don't mix them up. If you're looking at a Commonwealth piece of legislation, then of course, if there's need to refer to the Acts Interpretation Act, you would refer me to the Commonwealth version, wouldn't you? And likewise, if you're looking at a piece of state legislation, such as the Sale of Goods Act, Queensland, and you want to interpret that legislation, you'd refer me to the state version of the Acts Interpretation Act. All good? So when you're interpreting legislation, remember, of course, to look at the purpose or the object provisions, which are usually contained in the Act. Have a look at the interpretation provisions, which might be a dictionary, always very important. And don't forget the extrinsic materials, which are as closely related to the Act as possible, such as some explanatory memorandum or explanatory notes. Any questions about what I've said? All good? All right. So if you haven't yet looked at the Personal Property Securities Act 2009, Commonwealth, I'd ask you to do that. I know that's week 5, but it will help you with the content of week 4 material. Do try to get an overall idea of the historical aspects of property law, but don't dwell on it too much. There is a key thought with property law, and it's this. Think of property in terms of a bundle of rights over things that are exercisable against others, rather than the generic concept of ownership. So think about what your rights are as against an individual, which is in personam, or against the world, which is in rem, when you're thinking about property. And you know that in personam, in rem, that relates to personal property and real property, doesn't it? In personam, in rem, personal, real. So you'll see a few tie-ins there as well. Remember, of course, that there is a distinction between the common law, black letter law, and equity, and it's merged now by and large, but not every court has equitable jurisdiction in all matters. So different courts and different tribunals have different abilities to actually deal with different distinct legal problems that might turn up. Just on assessment work, sometimes we get some questions about Turnitin, and don't be overly concerned about a high score on Turnitin. It may be that if you've referred to extrinsic material and you've referred to it by referencing, you might have a high score on Turnitin, but that doesn't mean that you've done the wrong thing. It might be perfectly acceptable. You've quoted from legislation, primary sources, etc. All right. I'm going to try to give you, at least for those of you going straight into evidence, try to give you a couple of minutes break. So we'll wrap it up now. Thank you very much for your patience. Oh yes, next week. Okay. Something a bit different for next week. I've never tried this. We'll see how we go. What I'm going to do is, from time to time, I do record a session, and I'll record the session my monologue, if you like, for week 2, I'll upload that to view at your leisure. But what I'm doing is I'm going to hand the live session over to you, and I'm going to ask for people, for want of a better term, to become champions in this unit. I have been a little concerned over the last couple of years at what I perceive to be a general lack of collaboration. And given that I'm very keen on collaboration, I do want you to have a platform for that. So look, I may pop in and visit during the session, but I would really like Wednesday next week, week 2, it's just for next week, to be your session. And to do that, I'd ask that people think about their own personal skills and think, well, can I lead the discussion or can I assist others? Not in a conceited or arrogant way, but just as an acknowledgement, I'm pretty good at this and I think I can help. And it looks like, Lockie, you've already got some votes, so you might have to be one of the champion. I hope you understand what I mean. I did this once in Introduction to Law many years ago, and people really came to the fore. And what we found is that some people were very strong in certain areas and they were able to assist students, their colleagues. So if I can ask you to do that, that would be very good. Now, you don't have to join the session, you don't have to contribute, but if you can and you're able to do it, I'd really appreciate it. So 7 o'clock next week, can someone, so don't wait for me. Once you've logged on, start working, if that makes sense. But you will still get some contribution from me. It's just that it'll be pre-recorded. All right. Any questions about what I'm hoping to achieve next week and why I'm doing it? Otherwise, I just spend all the time talking. Okay. Thank you very much for this session, and I'll see you in 2 weeks. All the best. Bye then.